Israel. Oh, sorry. Here we go. Okay, so um, yeah, thank you so much. Just a quick overview on Centro Legal's history. Oh, sorry. If we can just really quickly just kind of go over it. We were founded in 1969 in the Fruitvale in Oakland by former Berkeley Law students. It's grown into quite a big organization since then. It used to be very small, but now it's grown into three teams: the workers' rights team, the immigrants' rights team, and the tenants' rights team. And of course, we're from the tenants' rights team, and we're going to talk a little bit today about tenants' rights, especially during the Alameda County eviction moratorium. Next slide, please. So a little bit about what we do. And I'm going to try to move a little quickly because I know that Judy gave you a promise here for time that will leave, and we have quite a lot to cover. So if you hear me going fast, I'm just trying to get to everything. But we do a lot of outreach and advocacy. We try to reach out to the community to see what their needs are, talk to them during consultations as well to understand more holistic approaches if they need, for example, a different community approach to their housing situation where they can potentially organize with other tenants, neighbors, things like that. We also do advocacy, which resulted in the moratorium that we see today in Alameda County. We were part of groups that were pushing for these protections on the county level. We also help tenants with evictions, fighting unlawful detainers. We help tenants have issues with their subsidized housing or different fair housing violations. And of course, recently, especially during the COVID period, we've been helping tenants a lot with rental assistance applications. And we also do some affirmative litigation. So that's when tenants will usually together in a group or by themselves will sue a landlord for different issues. Next slide, please. And if you or if anyone that you know has any sort of housing issue, please have them contact us. We'll have all of our contact information at the end. So this is just an overview of what we're going to be talking about today. We're going to be going over the different the different aspects of the eviction process, the protections that we have currently in Alameda County, and also statewide protections, different statewide laws that will interest you, and then also talk about some common issues that we have and hopefully leave time for questions. Next slide, please. And I apologize to the interpreter if I'm speaking a little quickly. I know I interpret sometimes too, so I understand. And so we're going to get started with the eviction process. Next slide. So this flowchart, this image here will guide you through the entire eviction process, and you don't have to memorize it. We can send it out to our contact here, and then hopefully maybe they can distribute it to everyone. This presentation is also being recorded, so you can look at it later. The important thing to remember, though, is that this is a legal process in the sense that all tenants have a legal right to it, and it is a process in that it takes some time, right? So landlords can't just tell a tenant from one night to the next, just get out, I want you to leave, and then the tenant has to leave the next day, right? There's a legal process that they have to follow, and sometimes if they don't follow that correctly, for example, if they don't give proper notice, that might really help the tenant in that they might not be going through a valid eviction, which means that they might not have to leave. So there are a lot of technicalities to it. It's not as simple or as informal as some landlords want it to be sometimes, but it's just important to keep in mind that this means that tenants have time. Usually when they're given a notice, they still have time to fight it, and there's still different defenses that they can do against the different forms of evictions that they might be facing. Okay, next slide, please. And the other thing to remember is that just because you received a notice doesn't mean that you have to leave, right? So like I said, there's a long eviction process, and only until you finish with that process, when the judge it essentially tells the tenant to vacate, do they have to vacate, and even then only on the date that the judge tells them that they need to vacate. But it all starts with something just like this. It's a notice to vacate. It could be a 3-day notice, a 60-day notice, a 30-day notice. It kind of depends sometimes, depending on how long you've lived there, what someone might be getting the notice for. But all notices require some information to be present, like a name, an address, the correct name and address, of course, of the tenant, the reason why they're being evicted. And there are these different things that need to be in the notice in order for it to be valid. So if a tenant receives a notice, we always really urge them to contact us, because it could be possible, as I said before, that it's an invalid notice. And that means that they may not be entering into an eviction process. Even if they move forward in the court, the faulty notice is a great defense to the tenant. Next slide, please. But if the landlord does move forward with it, the next thing for the tenant to anticipate receiving is something just like this. It's called a summons, or it's the beginning of the unlawful detainer eviction process that they'll receive from the court, these court documents. And it's important to keep an eye out for these, because they'll have really important information, like the date when you're scheduled to go to court, but also really important to contact a legal services organization like Centro Legal if a tenant receives these documents, because they have 5 days from when they receive these documents to file a response, what's called an answer, to the court. Otherwise, if they don't file a response, they could automatically lose their case. So it's really important that if a tenant receives these court documents, that they immediately contact us at Centro Legal, because we can help them file an answer, or a different legal services organization. But it's really important to keep in mind that this is also still just the beginning of the process, right? So just because they receive these papers still doesn't mean that they have to leave. It just means that they're going to be now entering into the court phase of the eviction process. And again, as I said, if the landlord has any sort of failure or error, it creates good defenses for the attorneys, or for the tenants, and for the attorneys to use, of course. Next slide, please. And throughout this process, there's going to be different moments when potentially you can resolve it. One of them is the mandatory settlement conference, when you can potentially find some sort of agreement before it goes to court. This is usually a really good opportunity to negotiate and see if they're willing to stop the eviction, or to maybe if they do go forward with the eviction, give the tenant more money, more time, something to that effect. Whatever is whatever the tenant desires or prefers, whatever the priorities are, whether it's to stay, whether it's to receive more money or more time. This is an opportunity for them to do that outside of court or prior to court. If nothing is resolved at the settlement conference, if there is no settlement, then it will go forward to court after that. Next slide, please. And again, if you receive, or if you know someone that received a summons and they missed the deadline to those 5 days to respond to it, it's still not necessarily the end. It could, as I said, be really bad, but it's possible to still have some way around that. So it's really important to contact a legal services organization as soon as possible. Again, you can contact Centro Legal and we can help you with that as well. But we can try to get the tenant more time and try to figure out the best strategy for them. Next slide, please. Great. And I'm going to pass it off to one of our attorneys that is present here, Norali, to talk more about the county eviction moratorium that you're also anxious to hear about. Thanks.
Thanks, Lalo. Just to add a little bit to Lalo's great presentation, We provide legal services almost at every stage, which is before an eviction has been filed, but even at the mandatory settlement conference, there are same-day services either from us or other folks in the court that can help people with settlement negotiations, with filing answers. And so those legal services are available from us and also from other orgs as well that show up at court. I will ask Israel to go to the next slide. I'm going to talk to you all about the current state of the Alameda County moratorium, and then we'll get into some of the state protections as well. And so like Lalo explained, in normal times, landlords can file a complaint based on all sorts of reasons, depending on the type of tenancy that is at stake. Right now, landlords can't file most evictions. We've had this protection in Alameda County since March 2020, and we'll have it until 60 days after the local health emergency has been lifted. So we have it right now. And what it means is landlords can only file 3 types of evictions. The first type of eviction they can file is if they allege that there is some sort of imminent health or safety threat, or the landlord is planning to take the building off of the market. That's called an Ellis Act eviction, or if there's a government order to vacate. So right now there's a temporary suspension on most evictions, and we still have this protection in Alameda right now. It applies to all residential tenancies, including mobile home park residents. And even though you cannot be evicted now for rental debt that you've accrued, you are accruing rental debt. And I'll talk a little bit more about that. Next slide, please. So like I said, there's 3 exceptions to the moratorium that landlords can proceed on. It doesn't mean that landlords aren't trying to move forward with evictions that are outside of these 3 categories, or they're alleging that there's a health and safety emergency even when there isn't one. So it's really important, like Lalo said, to reach out to a legal services org if you get a notice, or especially if you get a summons and complaint, because that means you need to act fast. I've seen various types of complaints get through to the court that don't fall under the moratorium, and we can help get those kicked out, and tenants can advocate to get that kicked out themselves, but we need to make sure we catch them before they turn into a default judgment. Like I mentioned, you are still accumulating rent debt if you're not able to pay right now. And you will need to provide documentation to your landlord of being impacted financially by the COVID pandemic if that's the reason you can't pay. But you can never be evicted for the rent debt you're accruing if you've been financially impacted by the COVID pandemic during this moratorium period. So what that means is if you haven't been able to pay rent sometime from March 2020 until now and until the moratorium ends, you cannot be evicted for that. But you will need to pay it in some form, and your landlord may sue you in small claims court or start a civil case to get that debt from you later on down the road. But you cannot be evicted for it. Next slide, please. A lot of people are asking when the moratorium is going to end. We don't know yet. It depends on when the local health emergency is lifted. We know COVID numbers are low now, but they're rising again. It depends on the Alameda County Board of Supervisors decision. And so we always encourage folks and organizations that are working with tenants to reach out to their Board of Supervisors and their reps to tell them that this moratorium is still helpful in protecting them, because it could be lifted anytime, but we have it right now. Even if it got lifted tomorrow, we would have this moratorium for 60 more days. Another important thing for you to know is, like, all eviction notices right now, even for the exception types of evictions, need to have certain language in the notice, and they need to have the actual moratorium attached to it. So that can be a defense to an eviction case later on down the road. It still means that you need to respond to the complaint with an answer, but it's good to know that all cases, even if they're alleging certain things, still have procedural requirements. If you've not been able to pay rent due to the effects of COVID, we recommend that you start gathering and providing documentation to your landlord now that shows this. It can be as simple as, a letter from your former employer that says that you were let go or your hours were decreased, increase in healthcare expenses or childcare expenses due to school closures. So we just recommend that you start gathering those right now and even providing them to your landlord, because that will provide a defense later on down the road if they try to do an eviction case based on non-payment later on. The court's should not be accepting those cases now, but they might later on. So you want to be able to say, I provided proof. You need to provide that proof within 45 days of your landlord requesting it, or 30 days until after the moratorium ends. And so just so you don't forget to do that, we recommend that you start providing that documentation now and keep a copy for yourself. Next slide, please. So we have this Alameda County moratorium. It's much more protective than what the state ever passed. So we like to focus on that, but we do want to share a little bit about the state protections, because there have been some recent changes. And of course, the state protections came with rental assistance. Next slide, please. So there was a state moratorium, kind of. It was a protection for folks who couldn't pay rent, and it came with certain requirements. You had to provide a declaration to your landlord. You needed to pay about 25% of your rent debt. And so we're not going to go into that, because the Alameda County moratorium is much more protective than that and is still protecting you. But we want to tell you that there has been a recent change in the state law that has said, if you have applied for rental assistance and your application is pending, your landlord cannot evict you for that rent debt. And all non-payment cases under those circumstances you can't go forward with them until June 30th, 2022. We expect the Alameda County moratorium to just protect you through then or around then. So this doesn't really change what we've already talked about. But what we want to emphasize is that you can still apply for rental assistance right now and still can get on some wait lists. So in Alameda County, residents can still apply through AC Housing Secure. I provided the website up on the screen. Oakland and Fremont tenants can still apply to be on a wait list. And I put up the Fremont website up there as well. You don't need to provide documentation for the Fremont waitlist. You just need to provide your name. And as soon as they get more funding, and we hope they get more funding, they'll start going through that waitlist. If you haven't applied for rental assistance and you want to start trying other ways of getting it, because we don't know if more money is going to come through the state and federal government, you can also try reaching out to local organizations like Catholic Charities, Seasons of Sharing. And another thing is Centro does provide some back rent assistance for folks who are able to pay rent going forward who live in Oakland. So there are some funds here and there. I would check in with local orgs, keep an eye out on the HCD website as well. And we'll get into this more, and Israel is going to get into this more in his presentation, but you still have non-COVID protections. Even when these moratoria go away, you still have the right to not be harassed. You still have a right to get repairs, and your landlord has to accept rent when you pay it. So you still have strong protections, even when the Alameda County and statewide protections related to COVID go away. I think that's the end of my portion of the presentation. I'll pass that to Israel.
Yeah, hey everyone. So just going to go over real quick, as an extension of that, some of the statewide protections that we have over state law, AB 1482, and then just going to go quickly over that, and then I'm going to go over, I believe, habitability concerns and harassment concerns, which happen to be the two most common and significant reasons as to why people reach out to us here at Centro Legal. So AB 1482, right, important to know that it protects tenants after 1 year of living in a building, and it does have that rollover sort of period. So units covered after 15 years from when they were built begin having those 1482 protections. As an example of that, right, 2020 buildings that perhaps maybe were built in 2020, right, they're going to be grandfathered into these protections 15 years after the fact, which is going to be in 2035. Statewide just cause protections is something that prior to 1482, tenants throughout the state didn't have. Of course, here in Alameda County and in some neighboring counties, that was the case, but this is new at the statewide level. And then rent can't be increased more than 2 times a year above 10% or 5% plus CPI. So CPI just being the consumer price index, which is near or has a relation to the rate of inflation, right? And it also provides rent caps to single family homes, but there are exemptions. Tenants must be notified if tenants live in owner occupied 2-unit properties, or if the building is not owned by a large landlord or corporation, right? So if you are, for example, a tenant living in a single family home, and your landlord is like a mom and pop type landlord, you would be exempt from the statewide protections. But it's important to note here, right, that first time that we're having a statewide rent control, this is because 1482, and then that rollover period of which will eventually grandfather in newer buildings to some of these protections, including the just cause protections. So what are just cause protections? They help limit the reasons for evictions, right? Just cause, meaning that you have to give just cause to evict someone. Exemptions for folks that live in units in which they are sharing a kitchen or a bathroom with the landlord, if the unit was acquired for conversion to affordable housing, and then statewide, but also have larger local laws in Hayward and Oakland, right? So again, when we're doing that comparison between like what's going on statewide, what's going on, within our own locality, it's important to note that like here, generally speaking, we do have stronger protections, but the statewide protections are an expansion of things that we just haven't seen before in the state of California, which is why we feel like they're worth noting. So going back to just cause, right? Just cause, so an eviction can fall under these 2 categories, an at fault or no fault. As we can see here on the left-hand side, there are some common issues that you'll probably see if you run into tenants that are having concerns about a just cause eviction, or just like an eviction in general, non-payment of rent, lease violations, nuisance, criminal activity. And then on the right-hand side here, we'll see if the landlord has intent to demolish or substantially remodel the building, withdrawal from the rental market, if there's an owner or relative movement, and then if there's a government order. It's important to note also with no fault evictions that depending on where you live, you might be entitled to some form of relocation. So if you're dealing with someone that is being, or that they are trying to pass through no fault evictions, one, like I think you want to make sure that it's actually valid. And if so, take a look to see if they're entitled to some form of financial compensation. So just wanted to zip through that, but now I'm going to get to, I was saying before, 2 of the most common reasons as to why tenants reach out to us here at Central Legal: issues concerning habitability, and then issues concerning harassment. So first, we're going to get started with habitability. And it's important to note that state law establishes these standards that cannot be waived by contract, right? So if for whatever reason, a tenant's like reaching out to a landlord and saying, oh, actually, it says here in the contract that I don't have to do these things, and you signed it to the tenant, saying this to the tenant, it's important to note that these rights cannot be waived away. You will have these rights, and even if someone brings out a piece of paper and says, no, actually, you signed saying that you don't mind if you have terrible conditions in your unit. That is not the case. Strong protection on that end. And as you can see here on the left-hand side, just a number of protections that people have, including adequate weatherproofing, working plumbing, gas, and heat, and then hot water, cold water, the list goes on. A tenant's responsibility, right? So if we are having issues with any of the things here listed on the left-hand side or something else, we want to make sure that we're notifying the landlord for the need of repair, right? They can't begin making those repairs. They can't begin fulfilling their obligations if they're not aware of the situation, and then providing reasonable access to the unit. As I'll talk about in a second here, there are laws that state how often the landlord can come to the unit, how they have to give proper 24-hour notification for coming into the unit. Us as the tenant, we just want to make sure that if the landlord is going about it correctly, then it's not a major nuisance to us, that we are providing reasonable access to the unit. Landlord's responsibility, right? Maintaining the habitability of the unit, maintaining and making sure that the things, again, that we're seeing on the left-hand side of the screen here aren't an issue, or if they are an issue, they're not an issue for that long, right? Arrange for adequate repair in a reasonable time frame. We put in here 15 to 30 days, but as I'm sure you can all imagine, there are situations in which 15 to 30 days is way too long. It depends on exactly what is going on, and some things will require a faster time frame. You just want to make sure that you're clarifying that to the landlord so that they know that they need to work within a quicker time frame if that's the case. And then, like we were saying, landlord has to give you 24 hours notice in writing. It doesn't have to be like a super formal letter or anything like that. If it's an email, if it's a text message, that will generally suffice. But of course, you can challenge it to an extent, right? If that just like doesn't work with you, you can try to work with them on a schedule that makes the most sense. And of course, because we're still under COVID times, we want to make sure that we're accounting for any sort of risk on that end, right? So if they're coming into the unit, you could say something to the effect of, you know, I would appreciate it if you could come in wearing a mask, or if you're sending vendors or someone to make repairs to the unit, can we make sure that they are following some sort of COVID protocol? Forward here. If we're not necessarily seeing the response that we would like to see, right? Maybe this landlord's stalling on the repairs. Maybe they're saying, no, it's actually your responsibility to do these repairs. We're just not really getting to where we would want to go here. There are some ways in which we could advance things with some of these remedies listed here on the screen. A rent board petition, right, depending on where you live. So I know the city of Oakland has a rent board, city of Alameda, and perhaps maybe other cities do. It's just important to note that the rent board kind of has a narrow way as to the authority that they have and how they can rule. The rent board, typically what we see when tenants file a petition with the rent board is what's called a petition for a decrease in rent because of decrease in services. So maybe you live in a unit, heater's not working, you want to petition the rent board so that you get a decrease in rent because, yeah, you no longer have that service, which you should have, which you are entitled to. Rent board petition can rule on that, but it's not, their enforcement doesn't really go further than that in that case, right? You could also, affirmative lawsuit just means suing them. So if you want to consult a private attorney, generally speaking, we don't go on the affirmative that much, but at the very least, if someone was like, no, I feel like I got a really good case here, I want to sue my landlord, at the very least, we might be able to recommend them to a private attorney. That could be more useful on that end. And then also, just really important to note that habitability issues, if we're doing a good job of documenting them, they can be a good defense in evictions, right? So if it's really well documented, you're taking photos of the cockroaches in the unit, you've been tracking the mold growth in the unit for a while, the landlord tries to move forward with an eviction and for some reason it's actually going through, presenting these habitability issues and having it well documented can be useful, right? So what we don't recommend is repair and reduct. That's when you take it upon yourself to do these reparation or repairs and then try to get money from the landlord. There's just no guarantee that you're going to get that. And then withholding rent, right? I'm not going to pay rent if you don't do these repairs or if you don't do what I want. Again, we want to be in a good position in which if we ever have to present our case in front of a judge or anything like that, being behind on rent is not going to look good on our end. So next steps, document conditions. Like we were talking about, let's just keep good records of that. You call code enforcement. So some cities have their own code enforcement. Throughout the county, we have vector control, which is for infestations. They'll be able to document that and pressure the landlord to make repairs in certain ways. You also just want, if you're calling code enforcement, we just want to take into consideration and think about whether our unit is unpermitted or, yeah, if it's unpermitted, that could quickly lead to what's called a red tagging of the unit, which can quickly lead to a no-fault eviction. That's a consideration you want to take into consideration. And then again, figure out if you have rent control. Some cities do, and that provides extra layers of protections or considerations. And then organize with your neighbors. If you live like in a larger apartment complex, if you're having this issue, there's a good chance your neighbors are having it as well. You're stronger together. Just quickly here, I'm going to go over harassment. So similar sort of formatting, common forms, abusive right of entry. So what we were talking about before, they keep showing up. That's an issue. If they're not performing their basic obligations, they're refusing to do repairs, it also be a form of harassment. And then any sort of threats on behalf of the landlord can also be a form of harassment. State law makes illegal, unlawful evictions, utility shutoffs, right? So they shouldn't be shutting off your water, gas, electricity, retaliation, and then there's extra immigration related protections if you're being threatened on that end. And then in Oakland, there's the entire tenant protection ordinance, which is a beast of its own worth looking into, but provides really good protections to tenants and does a really good job of outlining what harassment can look like and what the protections are relating to that. So remedies, similar, right? You could sue, you could file a restraining order, right? If you're trying to create distance between yourself and the landlord, if that's a relationship that you don't feel is mendable and can become violent or just escalate in a way that you don't want to, that could be an option. And then, like we were saying before, if this is well documented and you need to present your case in front of a judge on the defensive, this can be an excellent defense. Lastly here, right, just next steps, document these instances, right? So like if you're receiving threatening emails from your landlord, hey, I'm going to get you out of here, I'm going to do X, Y, and Z. We want to make sure that we're documenting that because having good records is going to be really important later on. This is similar to what we were talking about with the restraining order. We want to minimize contact with the landlord if possible. If it's not a good relationship and you feel threatened by them, it's weird interactions are going on. We want to minimize that to the extent that we can. And then organize with your neighbors. As before, if they're harassing you, you live in a large apartment complex, or that this is also going on with some of your neighbors, there's a conversation worth having with them in order to build that sort of strength, that tenant power, to be able to organize around these issues collectively. And with that, I will pass it back to the team here.
Great, I'll jump in. Thank you, Israel. So we just did a quick couple of slides about the tenant protections after the eviction moratorium ends. We talked about that a little bit, but this is just a refresher. Israel, if you want to go to the next slide, please. So we're talking about like what's at stake post-eviction moratorium. We're obviously really concerned about folks who are still feeling the effects of the pandemic. Just because numbers are down doesn't mean that people aren't still experiencing the financial and traumatic effects of the pandemic. And then many people have lost work even permanently. And so we're concerned basically about a wave of evictions, both related to non-payment, but also other types of evictions that landlords are incentivized to go after right after the moratorium lifts. Next slide, please. But just as a reminder, the protections that Israel just reviewed with you all are still in effect. Just cause protections are still in effect. Retroactive evictions based on non-payment debt during the pandemic stay in effect. You can't be evicted for rent debt accrued from March 2020 through the end of the moratorium, although it is a debt that does accrue and can be recovered by the landlord through different types of court cases. Next slide, please. It's illegal to deny any otherwise qualified prospective tenant due to COVID-related rental debt. So if you have been able to get rental assistance, but your landlord won't accept rent assistance, make sure you document that, because that can be a defense to an eviction later on. You also cannot apply rental payment to past due COVID-related rental debt unless the tenant has agreed to that in writing. So that means if you've accrued rent debt for March 2020 through September 2020, and then you start paying rent now in 2022, that cannot be applied to your rent debt and then make it so you are not paying rent right now. You are protected from that unless you sign something. So make sure that you tell tenants not to sign anything to say that your current rent that you're paying right now applies to past debt. It's also illegal to charge late fees for COVID-related rent debt. Next slide, please. And then, of course, you have us as a resource. There are also other legal services organizations. Whenever in doubt, when you get a notice, especially when you get a complaint, reach out to a legal services org. But also we are seeing an uptick in harassment and landlords not making repairs during this time period because they believe that they don't have to do those things or are entitled to do whatever they want because they haven't been receiving some payments. And so if you are experiencing issues with that, make sure you document it in writing, keep copies, and reach out to us or another legal services org to ask for advice. And then there are also partner organizations that we work with. So Tenants Together, La Clínica de la Raza supports with health concerns. There's senior support through legal assistance for seniors. And as Lalo and Israel mentioned, tenants banding together, tenants in the same neighborhood, but especially in the same building, banding together always provides for more support and power to respond to unlawful behavior on the landlord's part. And so we always encourage that. So we just want to open up to questions. We took it to the very end of our presentation time, but we want to open it up to any questions. I also know we got some questions in the chat, so we'll take a look at those as well.
There is a question in the chat. Thank you so much. That was fantastic. Alina says, what I'm unclear about under the local health emergency, what criteria needs to be met in order for the county to declare that we are not under a local health emergency?
That's a good question. My understanding is they are looking at a number of different things. I think, of course, hospitalizations is a part of it, but I think we have a good coalition of people on the Board of Supervisors that understand that the health emergency is not just the number of people who are getting COVID, but also the risk related to, you know, if there's a huge wave of evictions that could lead to unhoused folks and a rise in COVID. And so I think they're looking at multiple factors, and we do advocate to continue the moratorium because we still think it's necessary. But we don't really have a sense of when it's going away exactly right now. I don't know, Lalo, Israel, if you guys have more information on that.
And I noticed Henrissa has joined us too from Centro Legal. So welcome to you too.
Thank you. Hello, everyone.
Yeah, that's the big question, is when is the Board of Supervisors going to end the health emergency? It's something we're all worried about. I had one other quick question. I know we're a little behind, but I want to ask my question anyway, which is the state law that you talked about. I don't even remember the name, but that applies to apartments that are over 15 years old. So that means if you have a new apartment, they can raise the rent as much as they want and more than 10%. Or I think, Lalo, you said there's going to be more added to that will make newer buildings apply to, but could you say a little more? Could someone say a little more about that?
Yeah, so I think on that end, just meant that, yeah, exactly. Like with some of the newer buildings being built, like we gave that example of if something is built in 2020, then add 15 years. And that's when I believe you're talking about AB 1482,
Right.
the so it's going to be statewide rent control protections or rent cap protections, and then just cause is going to apply to them. So meaning that, yeah, in that period for a building that's on the newer end, like something built in 2020, those protections aren't going to apply immediately. It's going to take that time for them to begin applying.
So essentially, this bill is a rent control bill for the entire state. Is that what it is? But it's not. It hasn't been signed yet. It's just what's in the legislature right now.
No, there is. So AB 1482 is a statewide protection and applies especially in situations for cities that don't have local rent control and local just cause protections. And so there are, like Judy mentioned, it's like there's a gap there with these like newer buildings. But just as a reminder, I mean, if you've signed a lease and are in a lease period, it's probably the case that your landlord can't raise the rent during that time.
True.
There's sometimes even rent control inside, you know, a lease where it says we agree that we won't raise the rent a certain amount. So before you pay a rent increase, we advise you to reach out to a legal services org. You might not be protected by the statewide protection. And if you don't have a local protection, that they might be able to raise the rent more than 10%, but we advise people to reach out to us or another org before they pay it, because there could be other things to protect them.
And sorry, I just also want to clarify, it's not, I wouldn't consider it a rent control act. It's more of like a rent cap. And I say that specifically because there's also state law like Costa-Hawkins that really limits the ability for rent control to exist in California. And this law actually kind of came out after Prop 10's failed campaign to repeal Costa-Hawkins. But just to say that there's still a lot of limitations for rent control in California due to state law. This is a really important law, though, because what we got out of AB 1482 is one workaround from that Costa-Hawkins law, which prohibits rent control from applying to single family homes. So in places where we have rent ordinances, like for example, in Oakland or San Francisco, those still do not apply to single family homes because of the state law Costa-Hawkins. But this law provides the only cap that we have on single family homes. There are some exceptions, like Israel mentioned, but it's the only cap that single family homes have for rent increases in the state of California, which is important, but it's just important to note that as well.
Thank you so much. We learned so much. So I want to thank all of you very much for spending this time with us. We did record this, so I'll send you guys the link so you have it as well, and afterwards I'll let people know how you can get
Oh,
it.
Judy, Roberto's had his hand up for a while.
Oh, I'm so sorry. Roberto, go ahead.
Oh, that's okay. I just have a real quick question. First of all, thank you very much for your presentation. It was great information. And the second thing is your services. When do you provide those in the area of Alameda County? Is it just Alameda County?
We provide services to Alameda County, if depending on income requirements. We have low income requirements that are pretty generous, but we do have some restrictions, and we also provide services in Contra Costa County.
Thank you.
Thank you so much.
Any other quick questions? Quick, because we're behind schedule. But I know we know how to reach you guys, and I want to thank you very, very much for this presentation. Okay, I'm gonna stop recording now.